Hello and welcome. You are watching Property Hotline with me, Kavita Krishnan. We have Vinay Singh in the studio today, and we are answering all your legal queries. And yes, of course, we will be answering any query that you have to do with demonetization and its impact on your home. Vinay, welcome to the show. Let's get started. We have an email query that's come in from B. Raman. Now, Raman wants to buy a house in Bengaluru. He had orally agreed last month with the owner to buy it as soon as he gave the documents. Now, he wanted to buy another property after that. Now, he claims that the sale deeds are not registered, as the percentage of registration fee and stamp duty are to be reduced from 8.5% to 4%, and the registration will not be on government value as done now, which I'm assuming is a ready-reckoner rate, but will be done on market value. He wants to know if there's any move to prevent resale of property at a higher value than what is registered in the near future. Can such resale at a higher or a lower price be prevented? Vinay?
Well, I don't think there is any move, and the rates that you are saying 8% also don't appear to be correct. It's 5.6 or 5.65 depending on whether it's in the city or the panchayat villages. There is nothing preventing you from registering an agreement at any value. However, if you register your agreement at a value lower than the circle rate or the ready reckoner rate, as it's called in different parts of the country, you will find that you will have to pay tax. The buyer and seller both will have to pay tax on the differential. So it's not advisable, A, because you will be subjected to a scrutiny, and B, you will end up paying tax, interest, and probably penalty. So I would not advise you to do that.
Vinay, I think there is a bit of confusion over here as far as the property registration process itself is concerned. Can you break it down for Raman and for all our viewers?
Sure. See, once you have agreed to buy a property, you need to go down to the sub-registrar's office, the sub-registrar of assurances, and register it under the Indian Registration Act of 1908. Different states may have slightly different processes for registration, because the entire machinery is the state machinery, although Registration Act is a central legislation. So the rates also the states will decide, so there may be a slight variation. For example, Bangalore would have a 1% rate. Maharashtra has a 1% rate, but there's a cap of 30,000 rupees. So there will be these small differences. Having said that, largely the process is the same across the country. For you to acquire title, you need to make sure that you register your agreement. So that is extremely important that you do it as soon as possible, because without that, even if you have paid the money, even if you have taken the possession, and you have a document from the other person saying he's received the money, you still do not get a title until and unless you register.
And registration again has to be done on market value or on the ready reckoner rate. What is considered?
You can do it at either, but as I said, income tax comes into play. And if you have registered at a value lower than the ready reckoner value, you are going to have to pay tax. So
typically, what is followed is registration is done at the minimum. Higher of
minimum. Yes,
higher
your agreement value or the reckoner rate, whichever is higher, is what everyone tends to do, and that is what I would advise you to do as well.
Right. So registration, the net, what you need to remember is registering your property is very, very essential. Registering the agreement, that is very essential, because this is the only legal proof that you have that the title of the property is actually in your name. It helps the government to transfer the title from the earlier owner to in your name, that is once you bought the property, which is why you register the agreement, and for that you're paying 1% as the registration fees. So you will have to register your property. Ideally, that's what you should be doing, and you will need to register it at the higher of whatever you paid, either market value, or that is the agreement value, or the ready reckoner value. You'll need to pay at the higher of the two. So that's something that you need to keep in mind. We have an email query now that's coming from Arun. Arun purchased a flat in Noida's Sector 78. The flat measures 1,250 square feet. Now, the builder has given him one free covered parking along with the flat. Total cost of the flat, according to the allotment letter, 66 lakh rupees. And this includes the one free covered parking, which costs 4 lakh rupees. Now, he wants to know whether he has to pay stamp duty on 66 lakhs or on 66 plus 4, that is 70 lakh rupees. 4 lakh being the cost of parking. Now, the builder has given him the offer of possession, stating that he has to get the free covered parking registered at a cost of 4 lakh rupees along with the flat. So first he was sold the flat along with the parking, saying the parking is free, and now he is being told to register the cost of the parking alongside the cost of the flat. What should he do?
Well, what I can see from your allotment letter, as you have quoted, is that the flat, inclusive of a parking, is agreed to be sold to you at 66 lakhs. So, as far as I can see, there is no question of you paying an extra 4 lakhs. Now, when you do go for paying the stamp duty and registering the property, it is shown as that there is a flat, there is a parking space of whatever nature it may be, and accordingly you would end up paying stamp duty on the minimum value. So if 66 lakhs happens to be higher than the reckoner value of both the flat and the parking, then that is what you will pay the stamp duty upon. Or if the value as per the reckoner crosses 66 lakhs, then you will end up paying stamp duty on that. But I don't see how the builder can demand anything extra from you at this point.
So the builder has no rights to demand anything extra from you at this point. What should he do ideally? I mean, obviously he should not be paying that the money for the parking separately and registering it separately. But how does he communicate this to the builder? If the builder refuses point blank, what does he do?
I think the right thing to do would be first have a valuation done from somebody there and find out what is the value. If it is equal to or less than 66 lakhs, then you pay stamp duty only on that amount. That should be the right way to go about it. So once you have a valuation, it's much easier to do it. If you're still not convinced, you can always ask the department to do an adjudication. So they will give you a value which is certified by the department. That is also equally good for you.
Right. But also, legally, are you allowed to sell parking? Because the law is not very clear on that, or people at least are not very clear on that.
Well, we have, at least as far as Maharashtra is concerned, we have a very old judgment of 2009 given by the Supreme Court that parking etc. cannot be sold. So now that it's a Supreme Court judgment, but it did emanate from a case in Maharashtra, so it applies at least in Maharashtra. In other places also, I would feel that if it's a common space, then the builder does not have any right to sell such a common area. He can sell specific, say a garage, but then a garage has to be a self-contained garage. It cannot be an open parking space.
Right. So by law, the developer cannot sell parking, and the very fact that he's asking you to register it, pay for it and register it separately means there is something fishy over there. You need to talk to the developer and tell him that, you know, this is not part of the agreement, because you've already signed an agreement over there. Hopefully you've registered it as well. You are going to register it, but you need to go and tell the developer that this is not part of the agreement. So according to the terms of the agreement, you do not have to pay that parking, the 4 lakhs extra for the parking. We have Anand Chaturvedi who's tweeted in now. He says that he bought a second apartment as an investment. He wants to know whether he's obliged to declare deemed rental income even if the apartment is not let out.
Absolutely yes. You will have to offer the second flat for tax based upon what is the notional expected rent were you to let it out. So that would be the stage one of your calculation of your gross income. From that you would of course get a 30% flat deduction as is allowable. The good point here is that if you have taken a loan to acquire this property, then any interest that you pay, regardless of any upper limit, is allowed to be deducted from this notional rent. So you will have to do this working, and if you have a lot of interest you're paying, you might well find that there is actually a benefit to you in terms of, you know, a notional loss, which you can actually set off against your other income while computing your total income.
So Anand, what the government is taking away from you in this case, the government is also trying to give back to you. So it makes sense for you to actually declare that notional income and avail the tax deduction that you can get on your home loan. We have a question that's coming through Facebook now. Yuvrajan Vadivel has written in. He says that he booked a flat in Electronic City Phase 1 on November 7, 2016. But the developer is not ready to negotiate. Should he cancel the deal or go ahead? He's not very clear about negotiating what, but I'm assuming it is a price. What would you say?
One thing I can tell you, if you have already agreed to a price with the builder, it is quite unlikely that he would negotiate under normal circumstances. However, nothing prevents you from making that attempt. Whether to cancel the deal or not will depend on your assessment of whether in the next 6 months are the prices likely to go up or down. Generally, that is how people make the decision. So if you feel that the prices will either be steady or they will go up, probably you should stay invested. However, also take a look at the project itself. Is it ready to take off? Are there likely to be delays? Does the builder have funding to complete the project? If the answer to these questions is no,
you know,
or any of them.
We have a lot of people who come in and tell us this, but how do you actually, as a lay person, as a buyer who really doesn't have access to data like this, how do you figure out whether the builder has enough money to complete the project, whether the project is ready to take off, whether it will get delayed in future? How can the buyer figure that out?
Yes, it is not very easy, I understand, but you can make inquiries. For example, you can definitely check with the local ward office, the proposal department, whether have the approved plans been cleared or not. Mumbai, for example, the BMC does put up some of the approvals on their website. So that could be one source of information. Or you can straight away go and lodge an RTI. They are bound to reply to you within 30 days. So you will come to know what stage it is at. Meet other people from other projects, do some site visits, see whether there is any activity happening there. If you can connect with people who have booked in other projects, ask them what is the status. If you have friends in the banking industry, they are also a good source. So generally it's not one thing. There are so many avenues from which you can collect information. Do all of them and then try to form an assessment as to whether you should stay invested or you should even take your money with a small penalty, etc., that you might have to pay and get out of the project at this stage.
And Yuvarajan, there are these other anecdotal, there's other things that you can look out for, where if you are planning to buy into the project, which you obviously are, then what you need to also do is check the site, visit the site at least at 3 different times of the day. See if cranes are moving, see if there is work or happening on ground. That also gives you a sense of whether or not the developer is, well funded. Another thing that you can also check for is if the project, if you can actually see the building, if the building has been constructed, then drive past at night and see if the lights are switched on. If the developer is willing to spend money on lighting up the building, chances are the developer wants to finish the project, sell it and move out. So these are things that you can keep a lookout for. And another thing, of course, like all the experts on this channel have been telling you over the last 1 week, the buyer is finally in the driver's seat. This is a time that you should go ahead and negotiate for a deal. Developers want to cut deals now. So seize the moment, go ahead, cut a deal, try and negotiate. Do not lose out on that opportunity. We have Satya now who's called in from Chennai. Satya, what's your question?
Hi, good evening. My question is, actually, I invested in a flat in Chennai. It's in 4 years ago. I paid the builder check. The biggest mistake I did, I paid in one shot because the builder was one of my relatives. He knows him. So I paid in one shot 7 lakh rupees as a check payment I made to him. And then actually, in those days, I used to work in a foreign country, and the builder who promised me to complete the things within 9 months. But after that, when I was busy working there, and this fellow just keep on giving me excuses that the project was not started yet. So now finally, it's been like 4 or 5 years now. I came back, and now the project is over. But what he did it in between, he couldn't able to finish the thing, and so he handed over the project to some other builder. He completed it. Hello?
Yeah, go on, Satya. We're listening to you.
Yeah. So he completed the thing, and now there's a conflict between these two builders. Actually, the person with whom I paid the money, it seems like that he didn't pay the money to the one who built the building. So now there's a conflict between these two builders, and I'm suffering in between. And I made a sale agreement to the builder whom I gave the 7 lakh checks. And in between also he promised me something, and then he took 3 more lakhs from me. So total 10 lakhs I paid to him. And now the situation is that the building is ready. These two builders are fighting, and then I'm just staying in Chennai. But basically I'm not from Chennai, from Maharashtra, but I came here and I'm residing next to the building only. I'm taking a rented flat and I'm staying there only. So it's everything. Then our total 6 flats are there, or 5 are occupied, and one is mine. One's still there, empty. It's locked. So I want to, if is it advisable, because advisable whether I should go and lodge in complaint, because what I had doubted.
Okay, Satya, the agreement that you have. The agreement that you have, does it say which flat in the building will be allotted to you, the size of the flat, etc.? Does it have all those details and the price at which you bought it?
Yeah, it has all the details, but again, there's a trick. Actually, what happened? For example, the total land, the land where he was, did all the Bhumi Puja, everything. Half of the land he sold later on. Later on, before I paid the money, when I paid the money, after that he sold half of the land.
Okay.
And this thing I came later, and the agreement which he made was that land piece of land he sold, and the half of the land which was there, he made he made the building. The building is there on that land. But I have the agreement. To say I have the papers, every papers.
Right.
The sales agreement
Vinay,
paper.
what would you say? What should Satya do?
Well, what I can see is that the building is ready, and you're saying out of 6, 5 people have occupied. You appear to be the only person who has not been given possession. So I don't see what could be the hitch. If the building is ready and the occupancy certificate etc. is received, I think first you must press for immediate possession. And if that is not forthcoming, then of course my advice to you is that you move the consumer court right away. If the building is ready, there's no reason why he should not give the allotment to you.
Right. So that's your answer there. What you need to do is walk up to the developer and claim demand possession. Basically, you have an agreement in your hand, which is proof enough that you have paid the money and you own the flat. And if he refuses, send him a legal notice, take him to court, go to consumer forum. You should find that should ideally, it should take how long, Vinay?
Consumer forums depends, varies from place to place, but generally 2 to 3 years is what we are seeing here in Mumbai at least. That might be a little here or there depending on the load.
But will the fact that he's waited so long, he's saying about 4 to 5 years, will that will that be a problem if he approaches the court now?
No, there is a failure to give possession, which is a continuing failure. So not only can he claim compensation, in fact even the rent that he is paying because he has not been given possession, he can definitely claim that as well.
So there you go, Satya. Ask for the possession of the flat and also ask that demand, in fact, that the developer pay the rent that you are paying because you've not got possession. Ask for the rent along with interest. We have Krishna now, who's called in from Chennai. Krishna, what is your question?
I have 2 questions. One is that I recently paid a 10% advance for a villa project, and subsequently I came to know that the project, there is a waterlocking is happening. So I did not sign any agreement with the builder as such, because the agreement time is 2 months from that time, and that is coming very close now. And now I want to go and cancel my advance, cancel my application, and I want him to pay the full money back. So he's saying that a lot of presentations I sent wherein it was mentioned that we'll pay the money back to you only after we find some other buyer to take that plot. And also that, okay, it may take cancellation charges also they'll deduct to the extent of 5% of the total project value. Since I have not signed any agreement, is it he's right in deducting and keeping me waiting for a couple of months more? That is my first question.
Right. Krishna, 2 questions. Do you have a receipt for this money that you paid him?
Yes, of course I have.
Okay. And also this, you mentioned that you went ahead and you spoke to the developer and asked him for a refund, etc. Now, was this done in writing or was this just an oral conversation?
I spoke to him over phone. Then he requested me to send a mail. I sent a mail to him that is what I want to cancel. So over phone he was telling me that it will take a couple of months more to get the money to you, and there will be at least 50% of the money what you paid will be the cancellation charges.
So Vinay, the developers asked him to...
An agreement as such, yeah.
Right. Vinay, the developers smartly asked him to send a mail saying that he wants to cancel the agreement, but has reverted on the phone, over the phone.
Krishna, I have a question to ask of you. You said that you want to withdraw from the project because there's some water logging. What exactly is happening there?
See, what happened is I'm new to the Chennai. So after I implemented, I paid the advance, I inquired with a couple of the people, and they mentioned last year when there were heavy floods in Chennai and the complete that project is submerged. So they said don't even book in that place. So that's where I came to know that I need to come out of the project.
Okay, see, if there is a defect in the particular plot or the entire layout, then you actually have a much better case, because if there is a defect, then he is bound to tell you about the particular defect at the time of booking. Now, I'm not very
Okay.
sure whether this is an actual defect or it is just a temporary thing. So, you can investigate that. If there's a defect, then that should be your ground. That you were not
Okay.
informed that this place is, prone to waterlogging, or there might even be some kind of a water body below it. It does happen. So, if these things have not been told to you, that is your best bet. If you send him a mail saying I wish to withdraw, then he's going to make you hold on, and he's not going to make you hold on for 2 months. It's going to be many months. That much I can guarantee you. So, if you want to get out of this, use whatever you can. If there was certain defects not made known to you, use that and try to get as much as your money out of this project and leave. That would be my advice to you.
So essentially, Krishna, you need to do some, basically evidence gathering over here, which will show that the developer actually did not tell you about the defect or the fact that there is a water body present which flooded that particular project or whatever. You need to do all of that and then approach the court. The other thing, of course, is that if the developer is giving you a response on the phone, be very clear and tell the developer that if I have emailed something, I expect a response by email. Ask for everything in writing, because that will help you in the court of law, which is very important considering that he doesn't have an agreement. What do you say, Vinay?
Absolutely. See, we always advise that when you pay money, you must enter into some form of agreement and register it, because that is what will ensure that rights and liabilities of both the parties are, spelled out in black and white. Now, when there is nothing and it's verbal, the builder naturally will twist it to suit his own purposes. So, it's not a good idea to give money without an agreement.
Right. So those are two key takeaways coming in on Property Hotline. One, if you pay the builder money, any amount of money, it could be just 1 rupee. But if you are paying the developer money, insist on an agreement. One. The other thing is, of course, that you have to register the agreement. And thirdly, do not indulge in verbal conversations with developers. Ask for everything in writing. Communicate in writing with the developer and ask for an answer, a reply in over email, or ideally in black and white in a letter. Moving on, we have Shama who sent in an email now. Shama wants to know what is to be done if one loses their property papers. She wants to know the legal procedure to retrieve it. Vinay, that's a very, very important thing that Shama is asking. How can you retrieve lost property papers?
Well, I'm going to presume that when she says property papers, she means a registered agreement. The first thing that you must remember is that as soon as you realize that you have lost or misplaced your registered document, you must be proactive and act immediately rather than wait till some future date when you decide to sell it. What we normally advise people to do is that you go and register an FIR. So, it is just a simple form that you need to fill up and lodge it at the jurisdictional police station, informing them that you have lost/misplaced your particular document. You do not have to justify how you lost it or where you lost it. You can just simply, for example, say it was lying in my cupboard and that is where we used to keep it, and now when I went to look for it, I can't find it there. So, that's all. Only thing is it should be lost in the jurisdiction of the police station where you go. So, that is number one. So, you will have evidence that it was lost and you notified the police. Next thing you do is that through a lawyer, you have a public notice issued that this document has been lost, and anyone has any claim or title to the property should say within 14 days, contact the lawyer. In 14 days, if nobody has contacted the lawyer, ask the lawyer to issue a certificate to you that he has given this public notice on your behalf. 14 days time was given and no claims etc. have been received. Now, once you have done these two things and you keep it with you, the third thing you need to do is you can go to the sub-registrar's office and ask for a certified copy of your document. Please note that just the certified copy is not enough because it's a public document, anybody can access that. But in conjunction with the FIR and the public notice, it shows that there is a genuineness which is very well established, and it also shows that you've acted proactively. Now, say after 5 years or 10 years, if you decide to sell the property, the fact that you did all this process 10 years ago will carry a lot of weight. However, if you wait and then just when 1 month before you want to sell, you go and do all this, then even the banker would, the one who's funding the particular transaction, he's going to view it a little suspiciously. So, these are the three things essentially you need to do.
You know, Vinay, this is of course, like you said, we are assuming that she had the papers, this was an agreement, and which is what got lost eventually. Now, we also hear a lot of people inherit property. And you inherit property from your parents, chances are that the property papers are not there. In that case, what happens?
Oh, I am not very clear actually what property papers would not be there. Say it is something from the local municipality that you can always get, there is no difficulty there. It is normally agreements which create a problem, or maybe a will. Now again, if the will was registered, you would be able to access a copy, which is again why we always advise people do register your wills. But if it's an unregistered will, then you would be in serious trouble.
Right. So if it's so say an agreement is lost, but the property has come to you through inheritance, a will is enough.
Yes.
Is what you're saying.
Absolutely.
So there you go. This is what you need to do very quickly if you've lost the property papers. First, file an FIR. Second, ask a lawyer to put out an put out a public notice in the local newspaper saying that this property is lost, and if there are any claimants, they can come forth. The papers are lost. If there are any claimants, they can come forth. And after that, you need to approach the magistrate, right?
Right.
So these are the things that you need to do, and do ensure that you do it at the earliest and do not do it just before you try to sell your property. Moving on, we have an email query now from Medna from Hyderabad. Medna said she bought a property 2 years earlier. It was not approved by the corporation then. Now she wants to get an approval. The agreement has been registered. She wants to avail loan on the land, but the bank is asking approval for the site. What should she do? Can she get approval after she's bought the property?
Approval from whom is the question, because I am not very clear about the facts here. If the particular project was not approved by the authorities, how on earth was the agreement signed? Normally it is not possible unless the plans are in place and duly approved. And second question I would have for you is that what was the due diligence done by you at that point in time?
With that, we come to an end of this episode of Property Hotline. Vinay Singh, thank you very much for coming and answering all of those questions. And we will, of course, help you with answers to all your queries related to real estate, whether it is buying, selling and investing, legal queries, home finance or taxes. You can also write in and send in all your questions related to demonetization and the impact that it could have on the home that you plan to purchase, the home that you plan to sell, or the one that you plan to invest in. Send in your queries through email, through Twitter, through Facebook, or just call in. I'll make sure that all your questions are answered by the experts in the studio. Thank you very much for watching. Keep watching Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.